Hello, my name is Rasmus Munk Søndergaard. I'm an attorney at law in the Kingdom of Denmark, and this is my essay called The European Constitutional Crisis. Europe is facing a constitutional crisis where legal development now occurs without the consent of the European peoples. Not unlike the US Supreme Court, the European Court of Human Rights has far-reaching political power. But instead of being based on a constitution, its mandate is based on a convention between European states to protect human rights. European states made binding international agreements to protect things like freedom of speech, Article 10 of the Convention, and the right to family life in Article 8, and gave the Human Rights Court, based in Strasbourg, the authority to rule on individual complaints about violation of the Convention. A widely known controversy in the US constitutional framework is how Supreme Court justices have introduced legal standards that were never included or presupposed by the founders of the original Constitution. A judicial elite that can freely invent new doctrines have the power to suspend state democracies and thus to overrule the will of the people. In the landmark decision, Roe versus Wade, a widely known instance of this, a majority of liberal justices intensely curtailed the ability of American states to prohibit abortion, a decision which was vigorously opposed by legal scholars as well as members of civil society. Differing schools of legal thought developed where originalists opposed the introduction of novel legal standards asserted by adherents to the doctrine of a living instrument. Former President Trump takes credit for the later Dobbs decision, where his appointees to the court helped to overrule the precedent set by Roe versus Wade and returned the right to legislate regarding abortion to state democracies. But whereas the US constitutional system, through the office of the president, offers direct ways for citizens to oppose undemocratic legal activism, no such avenues exist for European citizens. As Master of Laws, I wrote my finishing thesis on the case law on freedom of speech of the Strasbourg-based Human Rights Court. I was astounded to note how profound the bias was in the president of the court versus freedom of speech that could be deemed nationalist or hostile to immigration. Based on the thought of the wildly overrated Karl Popper, the court not only refuses to even consider sanctions against speech that is deemed to go against the values of an open society, thus potentially allowing for unlimited prison sentences for political dissidents. In certain cases, it even demands the punishment of such speech. I recommend this video on the philosophy of the open society made by the Irish Nationalist, Keith Woods. And here should be a link. It is, however, not only regarding freedom of speech that the convention system is downright hostile to the indigenous European peoples. Undemocratic judges made radical, nation-undermining decisions unsupported by actual conventions between European states. The first case of which is called the Hirsi Jamaa and others case, which was versus Italy, where the European Court of Human Rights found that Italy had violated the convention by returning migrant boats back to Libya that carried people who were spontaneously seeking asylum. At that point, Gaddafi had not yet been toppled, and Libya was a safe country to reside in. However, in an instance of this use of a so-called living instrument, the European Court of Human Rights decided that the mere possibility of these migrants being sent away from Libya and into hypothetical other countries that did not offer protections against torture, this carried such a burdensome risk that to send the migrant boat back was deemed a violation of the convention. Now, this judgment was quickly assumed upon by different migrant NGOs and pro-migrant organizations, and hailed as a revolution in the way that migration across the Mediterranean would be handled. And soon enough, the migrant crisis of 2015 saw large numbers of migrants losing life upon the sea. It should be noted that when the Australian government decided to stop accepting migrant boats that came from Asia, the deaths at sea for these migrants fell to 0. Whilst on the other hand, when more leniency was showed and acceptance of the migrants, it created such a pull factor that many chose to embark on the dangerous journey, spontaneously seeking to achieve residence in Australia. So that allowing leniency is in a sense providing that very thing that kills these migrants, which is horrible. Now, during the 2015 migrant crisis, these exact migrant routes with spontaneous crossings across the Mediterranean was caused directly by this revolutionary and radical piece of legislation from the judiciary. This was not the only instance of the European Court of Human Rights radically changing the landscape of immigration law and changing the destiny of immigration into Europe. In the case of Sufi and Elmi versus the United Kingdom of 2011, a major break was taken from the previous international law of asylum seekers. Now, before the Sufi and Elmi judgment, it was held that to be a genuine refugee, you had to be individually persecuted on the basis of your political opinion, religion, ethnic origin, or such matters. It was not sufficient to be hailing from an area that was subjected to turmoil or conflict or strife, but that was exactly what was held to be the new standard of asylum law after the Sufi and Elmi judgment. Sufi and Elmi were applicants to the European Court of Human Rights that complained they had their rights be violated by the United Kingdom government not allowing their residency, but ordering them to return back home to Somalia, where they were from the Mogadishu area, which at that point was plagued by gangs and chaotic sprees of violence. In another instance of the European Court of Human Rights going for extreme judicial overreach was the case of MSS versus Belgium and Greece. Now, the principle that undergirded immigration from third world countries into the EU was the principle of a secure outer border that then allowed for lax movement controls inside of the EU. The principle was to create a secure inner market, a secure zone of freedom of movement for European peoples, which was then achieved by placing further controls upon the outer borders. Now, this had to be combined with the existing frameworks for international asylum law, where it had to be determined who should have the responsibility to handle a request for asylum. This was agreed upon between the different European states under the Dublin Convention, where it was held that the differing European nation states had the responsibility to process claims of asylum in the first secure country that the asylum seeker arrived at, thus preventing the possibility of a kind of forum shopping where the migrant would arrive to a safe country but then go to whatever country would have the most generous social welfare states, places like Denmark, my home country. This was prevented by the Dublin Convention. However, in an instance of complete lack of judicial foundation, complete lack of conventional founding, the living instrument principle was again held to say that no, we suspend the Dublin Convention and call it a violation if Belgium chooses to uphold the Dublin Convention and send a migrant back home, back to the first country of registration, this being Greece. The reasoning for this was that the Grecian system had been so overburdened with asylum seekers that it was not able to sufficiently secure a respect for quality of life requirements of the asylum seekers in Greece. These examples of the European Court of Human Rights going beyond legal activism and radically legislating and affecting the entire future of Europe are not alone. Frequently, expulsion of criminal foreigners from European countries is prevented with reference to the rights to family life of the offenders, even though such protections was originally not a part of the Convention. Political authority derives from the people's consent, which is the essence of democracy and self-determination. However, the will of native Europeans is being overridden by unelected judges who are openly hostile to their own populations. This crisis highlights the need for a well-thought-out constitutional system that respects national sovereignty, which can then replace the radical convention system that is currently in place. The European Court of Human Rights system must either be totally discarded and revolutionized, or a middle ground solution must be found that retains the securing of civil rights and freedoms among a United States of Europe without compromising nations' traditional sovereign rights to determine who resides on their territory. Brexit showed that opposition to the EU could be implemented politically through referendums. But without a vision for what should follow, the movement to reclaim sovereignty was slow, ineffective, and chaotic. The European right wing must learn from the lessons of Brexit and start formulating serious constitutional visions for a less self-destructive system of European cooperation. European nations should form alliances and push back against judicial overreach, and nation-states should demand the right to opt out of the ECHR precedents via referendums, and to reclaim sovereignty over territories and freedom to determine who should be allowed to reside on those territories. Like with Farage, national parliaments should give citizens of Europe the chance to vote directly on whether it is truly a human right for criminal foreigners to have residence permits, or whether the unelected judges of the ECHR should bend the knee and back off. This should be driven forth as a wedge issue, and political parties should be shamed if they choose to deny their citizens the right to a say on their own laws and allowing unelected judges to shape Europe's future and flood nations with unwanted criminal migrants. The European right must embrace this direct conflict with the radical ECHR and lead the charge to restore national sovereignty and self-determination of European peoples.